Thank you very much, Mr. Speaker, and I'd like to thank my colleague from London who spoke earlier on this bill and the commentary from all members on Bill C-51 today. I think at the outset, because I have some time today to give a bit of a longer speech, I want to address the fact that I'm troubled by the fact that in government, the Liberals are doing exactly what they said they would not do in opposition. And in fact, this is our second omnibus justice bill. I know my friend from Winnipeg, the Deputy House Leader of the Liberal caucus, likes when I quote some of his outrage in the past Parliament for the use of omnibus bills. But particularly when it comes to justice omnibus bills, I think the need for a lot of these provisions to be considered independently is the best way to go. It's certainly not as long as the latest Budget Implementation Act of 850 pages or more, weaving together a variety of unrelated things in the form of one bill. But here we have another substantive piece of justice legislation that is being presented in an omnibus bill. Breaking it down, there's some good parts to it, and there's some parts that we certainly have some challenges with. And I'd like to use my opportunity, Mr. Speaker, if I may, to highlight both the good and the bad. So the good, I think, is we need, as a Parliament, to show that we can speak as a united voice with respect to zero tolerance for sexual assault or not respecting the consent of an individual in the case of sexual relations of any kind, Mr. Speaker. So I think it's good that we're having a fulsome discussion on this part of the bill here today. In fact, several members have quoted from some of the case law that has led for the need for Parliament to weigh in to be very clear that someone that cannot provide consent necessary to engage in sexual activities when they're unconscious, Mr. Speaker. We need to send a clear signal from Parliament to do that. I think actually the Senate amendments take away that clarity somewhat, and I'm glad we're having that debate here with respect to 273.1 of this bill. The Supreme Court case that drove clarity in this area, Mr. Speaker, was very clear. They said it was not possible for someone to provide consent if they were not conscious, even if express consent had been provided ahead of time while they were conscious, Mr. Speaker. And I think Parliament needs to be crystal clear that consent evolves, Mr. Speaker, and there has to be a constant presence of consent and respect. And that is what this bill is intended to do. And in fact, some of the Senate amendments, which would almost create many tests with respect to this standards, I think actually confuses the issue. There needs to be a clear signal sent that consent has to be constant. And I think that's a signal as parliamentarians we have to send. I can say as someone of my generation, Mr. Speaker, seeing on campuses the debate about no means no, all these sorts of things, and how it wasn't taken seriously in the early 1990s, Mr. Speaker, and we're still having debates today about it, Mr. Speaker, where accused will try and suggest that consent was provided at some time earlier, Mr. Speaker, that consent was provided in the context of alcohol or substances, and then if someone is unconscious, that consent cannot be provided, Mr. Speaker. So the Supreme Court was clear, and I think C-51 and our updates to the Criminal Code send a very clear measure. There is no test we're going to perform, Mr. Speaker. It's a bright line that everyone, all Canadians, need to show respect for that commitment to consent in the context of sexual assault cases, certainly, Mr. Speaker, but it's basic respect, Mr. Speaker. I think we're in the era of the Me Too movement, and discussions of unsafe workplaces, all these things have been, I think, positive to make sure that people have a positive obligation with respect to their relations with someone else, to make sure that they adhere to the fact that there's always consent present, Mr. Speaker. So I think that's clear. I'm also glad that a number of speakers in several parties have referenced Bill C-337, the bill from our former interim leader, Rona Ambrose, Mr. Speaker, with respect to judicial training in the context of sexual assault trials. As I said, the context, even in my generation, Mr. Speaker, of campus-level disrespect for the concept of consent, Mr. Speaker, the bench is comprised of a cross-section of society, Mr. Speaker, and those attitudes need education. They need to make sure that judicial standards adhere to the expectations we have as a society today of respect and consent, Mr. Speaker. We know in Ms. Ambrose's home province of Alberta, the case of Justice Camp, Mr. Speaker, where attitudes towards a complainant, a victim, by the bench can show just how disconnected some may be. I know that the vast majority of the bench would be explicitly mindful of the complainant in those cases, Mr. Speaker, but we've seen cases in recent years that shows that judicial training with respect to consent in the context of sexual assault trials is needed, as is that education for all members of the bar. As a member of the bar, Mr. Speaker, I'm glad a few years ago the law societies in Ontario and across the country have incorporated CLE requirements, continuing legal education requirements for lawyers to make sure that they're aware of the law, of expectations with respect to the law and consent. The very fact that there would be some reluctance to have that same sort of continual legal education for judges in the context of sexual assault cases, Mr. Speaker, is troubling. I know most justices are demanding that level of CLE, of education. So I would hope that the government, in the context of me starting off my address by talking about some of the positive elements of C-51, pushes C-337 through. It shouldn't matter that it came from a Conservative member of Parliament, Rona Ambrose, who's no longer in this Parliament, so I can say her name. It shouldn't matter that it came from this side of the chamber if it's trying to address the same elements I'm saying that I support in C-51 today. So let's hope we can see some movement in the Senate so that in the spring, Mr. Speaker, we can ensure that that's an expectation for all members of the bench to have that training so they can guarantee an environment of respect for all complainants that come forward, Mr. Speaker. And I think the provisions in 273.1 also show that Parliament is clear in its direction with respect to consent always being a requirement, and if there's any uncertainty, you err in the side of the complainant, Mr. Speaker, and everyone should know that if circumstances change, be they the context, the consciousness, alcohol, these sorts of things, prior consent is not sufficient, Mr. Speaker. We have to be crystal clear on that. I will say that this is also similar to the fact that we've had the Bill C-75 Omnibus Justice Bill, Mr. Speaker, which I've spoken to in this Parliament. I've also spoken to Bill C-77, modernizing criminal justice within the context of the National Defence Act. I supported a number of measures in that. In fact, the previous government had introduced Bill C-71 in the last Parliament, trying to update the National Defence Act and the treatment of criminal conduct by members of the Canadian Armed Forces. That's still in a state of flux, Mr. Speaker. But all of these bills, particularly because they deal with the rights of an accused, the rights of the victims or the complainants in these cases, Mr. Speaker, these should be given specific attention and not put into omnibus-type bills, Mr. Speaker. I would like to speak for a moment on the fact that this bill is part of the process of requiring a charter statement from the government with respect to legislation before the House of Commons. And I have some concerns with that approach, Mr. Speaker, in two ways. First, I'm worried that it may send some sort of chill to suggest that the government is trying to inoculate itself by saying we've reviewed the bill ahead of time and here is our charter opinion on it, meaning therefore you cannot raise charter concerns, or therefore there's no reasonable basis to have concerns about validity under the charter by groups that may be impacted by the decision of this Parliament. The very nature of the charter itself, Mr. Speaker, was to give a back-and-forth test with respect to the will of Parliament and the ability for the court to determine whether fundamental charter rights were breached directly or indirectly by legislation, Mr. Speaker, in the context of enumerated groups under Section 15 of the Charter, expressly contained within the Charter, or analogous ground groups provided by subsequent court decisions. The balancing test under Section 1 of the Charter, the Oakes test that certainly I learned in law school, some of the first Charter jurisprudence, is that balancing of the Charter. The government, by issuing a charter statement, I'm quite concerned that they're trying to suggest that they're doing their own Oakes test, their own charter examination of issues at the time they're passing legislation, Mr. Speaker. I'm not suggesting it will cause chill, but I haven't heard an argument from a member of the government bench to suggest that this is any different than any government since the mid-1980s when the Charter came into effect, Mr. Speaker, by suggesting that the seal of approval for the Charter is granted by one of these statements is simply ridiculous, Mr. Speaker. It is actually up to the court to provide that reasonableness and those limitation tests under the provision of Section 1 of the Charter, which allows a charter right to be violated by legislation, but applies a reasonableness and a balancing test to it since the Oakes jurisprudence started, Mr. Speaker. I'll use a couple of examples of why I have this concern. In this Parliament, we've seen many instances of this government acting in a way that I firmly believe violates the charter rights of many Canadians. Mr. Speaker, why this is germane? Because just today, shortly before we rise for Christmas, the government is reversing its position on the so-called values screen for Canada summer jobs, Mr. Speaker. We all know that the controversial values test was applied for the first time in the history of this summer employment plan for youth, Mr. Speaker, as a clear way this government intended to exclude faith-based organizations and other service organizations from funding related to students. There were concerns from a charter basis expressed from day one when it came to the values test, Mr. Speaker. So is the government suggesting with its charter statements that their actions on a whole range of decisions are somehow inoculated because they're providing a charter assessment, Mr. Speaker? I would say that's political theater. They cannot provide their own charter assessment. They try and craft legislation that they feel strikes the right balance, but the actual charter determination is made not in this chamber that writes the laws, in other courts, Mr. Speaker. We bow to you, Mr. Speaker. We have a bar there. This is a court. We write the laws, but we don't adjudicate our own laws. And this is a very big distinction that I've not heard the government yet express any clear indication on. I'll use another example, Mr. Speaker. There's been several violations, in my view, of Indigenous peoples' rights with respect to the duty to consult, Mr. Speaker. In fact, Bill C-51, I believe, violates that duty. The approach the government's taken on the cancellation of the Northern Gateway pipeline, Mr. Speaker, one-third owned by Indigenous groups. The duty to consult is not frozen in time, Mr. Speaker. It does not exist 10 years before you develop a pipeline or cut trees in a forest. If you decide to change the circumstances of that consultation or cancel something that Indigenous peoples are a one-third owner of, you have a duty to consult them on the cancellation, Mr. Speaker. This is an ongoing duty. The fact that the government may have a piece of paper that says this is our charter statement, this is our validation that this bill conforms with the charter, I think is political and inappropriate, Mr. Speaker, because they're suggesting this will withstand any judicial scrutiny before the judicial scrutiny is applied, Mr. Speaker. This is A-OK. I don't think that's the way it works, Mr. Speaker. I invite, the Justice Minister, Attorney General, and their Parliament secretaries to walk a little past the Confederation building on the Hill to a building called the Supreme Court of Canada, Mr. Speaker. It's actually there that the Oakes test was born, Mr. Speaker, the Oakes test where the Section 1 Charter Clause was. Because, as I've said, whether it was the values test that they did to politicize a Canada Summer Jobs program, that would not be inoculated because of a government-produced charter statement, nor would some of their actions with respect to Bill C-69, C-75, C-77. These are determinations by a court, Mr. Speaker. And as I said, I don't have any proof, because the charter statement concept is part of their justice reforms, including in this bill, but I do have serious concerns that it will send a chill to suggest that the government won't consider valid concerns people have with respect to their charter rights, Mr. Speaker. So I'd like subsequent members of the Liberal caucus, particularly, as I said, the ministers or the parliamentary secretaries, to provide a substantive rationale for their approach with respect to the charter statements, Mr. Speaker. Because are they somehow suggesting that previous governments, both Conservative and Liberal, have somehow not conformed to the charter by doing exactly how our system, or doing exactly what we're supposed to as a parliament, is try and find the right balance with the will of the people and with certain provisions within the charter, Mr. Speaker. That's done by a court using the Oakes test, doing the balancing, and producing a charter statement does, as I said, not protect them from criticism. In fact, Mr. Speaker, as I said today, the very fact that days before Christmas, they're suddenly admitting that their approach on the values test for summer jobs is wrong, much like last Christmas, just days before Christmas, they broke their promise to veterans on the return to the Pension Act, Mr. Speaker. The Liberals make very good use of the pre-Christmas period, not just for parties, but for dumping out their dirty laundry, Mr. Speaker. So I would like to thank the thousands of Canadians from across the country and many of my colleagues in this chamber for representing the charter rights of millions of Canadians with respect to the conduct of the Canada Summer Jobs Program. And as I said, my concern, why I'm focusing on this part of the bill, is we have to make sure that Canadians, members of the media, and members of this Parliament, both houses, don't get fooled by the fact that the government validating their own legislation under the guise of charter approval is not actually charter approval, Mr. Speaker. So I'm hoping in the remaining debate we can actually hear a cogent argument from the Liberal caucus on this, Mr. Speaker. Otherwise, it seems to be more of the sort of media spin that we see from the government. We had the Prime Minister just yesterday leaning on his desk, acting like a professor, telling the opposition what we should ask and what we should criticize, Mr. Speaker, when we know full well what we should, and we know where our criticisms and critiques are warranted, because quietly, when the House doesn't sit, they backtrack. That's right. Like today on the summer jobs values test, like when we rose for Remembrance Week, Mr. Speaker, and quietly Miss McClintock, another justice consideration, was transferred to a prison as we'd been demanding as the break week happened and the Statistics Canada suddenly pulls back their program, Mr. Speaker. I would suggest to the Prime Minister that most of our criticisms, the Chris Garnier, the non-veteran murderer that's receiving Veterans Affairs treatment funds, all of the things we've been raising, even though they make the Prime Minister uncomfortable, they've backtracked on, Mr. Speaker. We have been doing our job quite effectively. So I would like, in the remaining time, one of the Liberals to stand up and provide a context and a rationale to address my concerns with respect to charter statements with respect to this bill and others. But as I said at the outset, Mr. Speaker, we support the amendments and update of our criminal code with respect to sexual assault. Thank you very much.